Don't let your final farewell stir up family feuds. Welcome to Before You Go, a podcast brought to you by Texas Estate, Trust, and Guardianship Attorneys, Stacy Kelly and Keith Morris. Preserve your hard-earned legacy. Be in the know.
Hi, this is Keith Morris and Stacy Kelly, and we are here again with Before You Go, the podcast about things you should know about death and dying. We've taken a break for the summer, but we're back now. Stacy, any words for the audience?
No, I think we've decided today we're just going to ask each other some questions and kind of give some, short little answers so people can, navigate through the process after death.
Yeah. So, the topic today is the top 25 questions about probate litigation, and this is based on questions that we've received about things that cause folks concern and how they deal with issues after someone passes away, and then if there are problems as the probate process proceeds. So we got a lot to cover. We'll jump right in and let's go.
Okay, Keith, let's jump in. Okay, the first question, why is probate litigation so complicated?
It's a process where there are numerous parties, contested issues, and also the laws of Texas. So because of our experience, we know the complexity with these issues, and that way we can ensure that things aren't missed as we're going through the process. By example, the mediation we had last week on that case, we had 75, 80 parties, and we were dealing with some complicated issues about common law marriage and division of property. And so having someone that's experienced in that area can help navigate that in a way that will prevent there from being any errors when the estate is finally decided, the errors are determined, or the will is determined to be valid or invalid, and then the property is distributed.
Okay. What are the most common reasons for there to be disputes in the probate process?
So a lot of times people are dissatisfied with what the will says. There's we sort of divide will contests into three types, right? There's the kids versus kids. There's the kids versus second marriage parent, whether it be stepmom or stepdad, and then sort of the new emerging trend, which is family against random individual that inserts themselves in the life of the decedent, toward the end, with most of the time what we believe to be the intention, bad intentions to get them to leave their estate. So, it's a lot of times the disagreements over the will, disagreements over asset distribution. A lot of times it's that the executor or administrator fails to distribute assets. Sometimes it's fraud, sometimes it's undue influence. It really just sort of depends, but those are the kind of the common reasons that we see for will contests.
And once someone is appointed, either the executor or the administrator of an estate, how does someone like us, a probate litigator, how do we help protect that person, that executor or that administrator?
Well, in Texas, if you are a fiduciary, you are required to have counsel. So that's one thing that's important from the outset, is that you can't navigate that process on your own. So what we do is make sure that clients know what deadlines are, make sure that they properly account for assets, and also, one of the biggest reasons that we see litigation sort of being initiated is the fact that the executor or administrator fails to be transparent with the family. So we try to encourage transparency. I know you and I both do that because that helps to keep people from getting suspicious and that contention from building in the case.
Okay, and let's say there are disputes among beneficiaries. how is it that we can help navigate through those disputes?
Well, if we're representing the personal representative, which is either the executor or administrator, then before things get too heated, certainly, that transparency, like I was talking about with the beneficiary, is explaining the process to them. A lot of attorneys, when a beneficiary, when a state calls and they're representing the executor, say, "Oh, I can't talk to you," or "I don't want to talk to you," or just refuse to take their call. But I think that you and I have sort of learned through time that being more open with the family members and letting them know, where we are in the process. Hey, look, we haven't filed the inventory yet, so we can't make a distribution, or we haven't figured out the tax issues yet, so we can't make a distribution. Letting them know that there are legitimate things that are in the way of settling the estate. I think that's something that's very helpful.
And speaking of one thing that can come up that can delay the distribution of the estate, how does a probate attorney handle creditors' claims?
So there are specific requirements for creditors to follow in under the estates code in Texas in order to be able to assert a claim. So if the claim is not filed correctly, obviously we'll know that. A lot of times they think that filing an affidavit and saying this amount of money is owed without any justification whatsoever, backup is, and credit card companies are sort of the most egregious of the parties in this situation, where they don't provide additional information. They just say, here's the debt, the estate owes it, it needs to be paid. So our ability to look at those things and realize that they don't comply with the code according to what they're supposed to do really helps us to assist the personal representative in evaluating the validity of the claims. Now it's your turn. You get to answer some questions.
Okay.
So when you start on a will contest, what happens first? What is the first step when you're contesting a will?
Well, someone files a pleading in the court challenging the will for fraud, undue influence, lack of capacity. Once that process is started, that can tie up an estate for months or years while you're battling the will contest. When we're handling one, we gather as much evidence as we can to establish our position. Then once we're ready, we present the estate's case to a jury or to the judge and defend the will's validity. The nice thing about having experienced probate litigator is that sometimes we can still get things done within the estate and move things a little forward, even though we're contesting the will. Perhaps getting a temporary administrator in place, something like that, so that, once the will contest is complete, you're not starting at, the first step of administering the estate. Hopefully you can be getting it done while the will contest is going on.
And sort of dovetailing off something you said, in this process, as the litigator for the estate, how can you help expedite the process, the probate process, and move it along? One of the things you said was temporary administrator.
Yes, well, we know the ins and outs of the courts, the probate courts, the laws. So we can usually navigate that most efficiently than someone who's not versed in probate law or, probate courts and how they handle things. We can make sure all the pleadings are necessary, that, as you mentioned, or I mentioned before, a temporary administrator can help. Because when you're contesting the will, usually the court won't allow one of the contesting parties to be the administrator, pending contest. So if there's a lot that needs to be done and bills to be paid, you can get a temporary administrator in there to start handling all of that while you're just focusing on the will contest itself, and you don't have to focus on the estate.
Okay. And I'm going off script here, but just as I think this is helpful at this point, just tell everybody what a temporary administrator does.
Okay, a temporary administrator gathers all the assets, combines all the bank accounts into an estate bank account. If there's real property, it all depends on the dynamics of that particular estate. Sometimes the temporary administrator will sell things, especially if they're a wasting asset. The longer it holds on to it, it's decreasing in value, something like that. Cars are a big decrease in value quickly. But they have to have the permission of the court. So, every party in the will contest gets to have an opinion on what happens with the estate and what the temporary administrator does. Hopefully, so all the assets are still there that are, devised under the will. But sometimes that can't be accomplished. Sometimes the estate needs money. The temporary administrator needs money to pay debts. So that's what the temporary administrator does, is just kind of hold it as best he can until everything gets resolved.
And so when we're assisting the our client, who in this case would be the executor or administrator, how can we assist them in determining values of assets and preparing the inventory so as to because sometimes that is also a source of litigation, right? When a beneficiary believes that either an asset has not been included, or something that shouldn't have been included is included. And so kind of explain that, how we assist in that valuation process and preparing the inventory.
Well, that's sitting down with our executor or administrator and looking at each individual asset. The nice thing is we have lots of connections. I have connections at Sotheby's and some other places to value unique or very expensive assets, such as paintings or cars, or particular guns that might have a historical nature to them, something like that. So we have all those resources. In addition, we can do title searches to make sure whether certain real property should be in the estate or should not be in the estate. So there's a lot of investigation going on making sure that everything that's part of the estate is in there and that it's valued correctly. And again, a lot of times we're going to use outside resources on that because, I may not know how much a Van Gogh's worth, but I have people that can tell me. So.
Right, and that also includes things like joint tenancy accounts, being able to determine which ones are and are not part of the estate, right?
Oh, exactly. Right. And that would involve, sometimes looking at the particular bank account and the signature cards and the things that set up the account to determine, was it really set up properly to be a joint tenant or a payable on death account.
Okay. And sort of in that same regard, we assist the clients in determining the correct title to certain assets, both real and personal property, by in what methods and means. I mean, you sort of talked about that before, but elaborate a little bit on helping to distinguish whom is the rightful beneficiary of certain pieces of property.
Correct. Sometimes in wills, a decedent may leave a piece of property to someone that they don't really own, or that they only own a portion of. And in our advising our executor or administrator, we do the title searches. We determine what is really owed, and then we help quiet title if we need to. Perhaps this is a piece of land that the decedent inherited many years ago through a couple of different people, and those estates were never done. And so title doesn't necessarily rest in the decedent in the real property records. But we can assist them in cleaning that title up so that it does go into the estate, and then we can do a deed out of the estate to the proper beneficiaries.
And so one of the other important things that we talk about, and that we get a lot of calls about, is beneficiaries believing that the executor or administrator has mismanaged the estate. Are there things that we can do as the attorney, the litigator for our clients to prevent those things?
Well, you mentioned earlier about transparency. That's one of them, but there also needs to be transparency between the executor and us as their lawyers. I need to know, did you gather all these bank accounts? Now you have them in one estate account. We advise them to keep a record of all receipts, everything they spend. If they're going to put something in storage, let's talk about whether that's a necessary expense or not. I mean, it's just us having transparency and open communication with the executor, so we know exactly what they're doing and we can advise them before they get into a situation where a beneficiary could possibly have a complaint or even a cause of action against them. As a probate attorney, how do we assist with estate taxes?
Well, the best way for you and I as litigators to assist with estate taxes is to have them call somebody else in the firm who knows something about estate taxes. Neither you or I are a CPA or board certified in tax. So the best thing that I can do to keep everybody out of trouble is to either send them to a qualified CPA or to another lawyer in the firm who is a CPA and also an attorney.
Yeah, and one of the things that's always important when you're looking at a taxable estate and we're doing the inventory, those need to coincide, because the federal government could look back on the inventory. So before we even do an inventory in that particular situation where it's a taxable estate, we need to have a good idea, like you said, from like Marvin Blum or somebody to tell us about the estate taxes. So,
Yeah, absolutely.
what if the will is destroyed or missing? What can we do in those situations?
So there are well, first of all, if a will is destroyed by the decedent, then it's presumed to have been revoked. So, that's one issue in and of itself. If the will has been destroyed by another party who didn't like what it said, or if they disappeared the will, then of course you can probate a copy of a will. And a lot of times we hope that the attorney who drafted the will kept a copy. I know that you and I, whenever we do that, keep digital copy, and that could be probated under the right circumstances. Also, there's a procedure in the estates code where if the will is lost or missing, if you can have witnesses come and testify about that they read the will, that they knew what the contents were, and then all the other formalities required, that the testator was over the age of 18, of sound mind, and then you can submit that testimony in order to prove up a missing will. So those are sort of the two main ways that you deal with that, either probating a copy or having people testify about the contents.
What do we do in situations where the estate is insolvent?
So, there is an order of priority amongst creditors. There's class 1 through 8, and going into all that, I mean, that's an entire podcast unto itself. But depending on what class the creditors fall into, if there is not enough money to pay the creditors in that class in full, then essentially you do a proportionate share based on admitted value of the debt versus what remains in the estate. So, class 1 claims are funeral expenses and expenses of last illness. Let's assume, for the sake of argument, that you have enough money to cover all those, and then Then there's, expenses of administration, and we have the money to do that. And you skip all the way down to eight, which is unsecured creditors. Well, let's say there's $50,000 worth of credit card bills, but there's only, $20,000 left. They all will just take the proportionate share according to the value of their debt, in order to satisfy that claim. And we'll, do the math and make sure that everybody's taken care of appropriately.
As probate litigators, how can we assist in guardianship or conservatorship issues?
Well, so a lot of times we have estates where the beneficiaries are minors or potentially dependent adults. And so, we also do handle guardianships in the firm. And so, if it's necessary that, and we see that that someone's going to inherit something that may not have the ability to understand or accept that gift they've received, then we can assist by either setting up a guardianship or a trust, or some other method to make sure that bequest or that proportionate share of the estate, because they're a beneficiary, goes to them in the proper way.
What happens if, for all their efforts, what if it comes down to the court removing an executor or administrator? What happens then?
Well, we had that case recently where the executors were removed for breaching their fiduciary duty, and we represented one of the beneficiaries that resulted in the administrator, the executors getting removed. And so, in that instance, what we did was went to the court. The court approved of the removal, and then we worked with the other attorney to appoint a suitable third-party administrator to continue to administer the estate to its conclusion. So a lot of times that is what we do, and hopefully the attorney on the other side is helpful, and so that we can work together to assist that third party administrator in figuring out what's left in the estate and how to distribute it. So we do have instances where we have complex assets, we have high value assets. How do we assist our clients in those cases? And you talked about this a little bit before, I guess, with Sotheby's, but.
Right, but then also we have situations where the estate has an ownership interest or completely owns a business or a series of partnerships, LLPs, general partnerships, and you and I both are very versed in reading those company agreements to determine what happens at death and how those assets are managed and how they are ultimately distributed. We've also had situations where we have international assets. I know you had to go to France several times on one of your cases where you were the administrator and a great deal of the assets were over there. But again, that's just from, doing this 24 years and seeing all kinds of different assets. I was administrator, and all of a sudden I started running some aluminum plating company, and had to have corporate meetings. But again, that's where we rely on the other partners in our firm that set up these type of businesses that can help us get them to a point where they can be distributed.
We talked about this a little bit earlier, but how do you and I assist clients when there are disputes over the non-probate assets?
Well, again, I did. I kind of mentioned a bank account where, if somebody challenges that the bank account should have been probate and it should have gone into the estate as opposed to a joint tenants or a payable on death, we would look at the documents that created the account to see how those were done. Were they done properly? It used to be, I don't know, 10, 15 years ago, you could always catch somebody and not filling out a form correctly. But I think as time has gone on, banks have gotten better at that, and they're they've ensured that they're properly created. We also deal with life insurance. If you think that the beneficiary designation, naming someone else as the person that gets those life insurance benefits, and you think the beneficiary designations were a product of undue influence, fraud, again, we can challenge those. We can help resolve that issue. Retirement benefits is another one that, depending upon the plan, ERISA could control. And I mean, that's a nightmare statute to get through. Luckily, I have a great deal of experience with that. So, I think we've seen most everything on non-probate assets. And just because you're probating a will doesn't mean those assets are not going to come into play, and that there's not going to be issues to resolve those.
Yeah, and the thing that you were talking about in relation to the ERISA plan was, and we've had quite a few of these cases recently where husband and wife got divorced, and then the beneficiary designation was not changed on their benefits, and there was a whole body of law related to that, some of which you were responsible for making. So, that's one of the things I guess that we have to deal with pretty frequent and more frequently now. So, I guess our advice to those out there is, if you get divorced and you want to make sure that your benefits go to the right place, then make sure you change your beneficiary designation. So, obviously, when we are representing the executor or the administrator, but specifically an executor, we have to ensure that our client complies with the terms of the will, correct?
Yes, absolutely. Some,
How do we do that usually?
well, we have to have a good understanding of the will and know what the terms are and what our executor is supposed to be doing as far as that is concerned. Making sure we have the proper beneficiaries, that we are reading the will correctly to know which assets go to which beneficiaries, making sure that our executor understands the terms of the will and what the ultimate outcome should be, and then walking it through them step by step with them.
And, sort of going along with that, we don't have a standard form for a will in Texas, and so there are many different iterations, and sometimes there are terms in a will that are either conflicting or confusing, or conflicting and confusing, and it's our job to sort of help navigate that process, right? I mean, that's a big issue that we have when people don't, when their verbiage is not easy to understand about their how they desire their estate to be administered.
Well, I have a will. Yeah, I have a will right now that on the face of it, when you read it, most executors would think it reads a certain way. I have analyzed it and I have found out, or come to the conclusion, which the court agreed with, which is that 10% of the estate is not devised to anyone. It's just sitting there. And so we have to go do an heirship to determine who the natural heirs are for that 10%. So although it's a, valid will and in probate, we still have to do that extra step. So a lot of it is knowing how to interpret the will. Yeah.
Yeah, that's because there's not a residuary clause, right?
Correct.
And we addressed this earlier, and the answer is somewhat simple, but you cannot serve as a fiduciary in Texas, with a few rare exceptions. I think there are a couple of county courts that don't necessarily enforce this, but you can't serve as a fiduciary in Texas without an attorney, right?
Correct. I mean, you just need one. The risks are too great, even if that weren't the law. The risks are too great for an executor to try to do this all on their own, especially when you have different beneficiaries coming at you with different I need money now, write me a $20,000 check. Well, the executor needs to know if you're going to make a partial distribution, you have to make it to everyone. You can't just make it to one beneficiary. And if you don't know that and you just go ahead and write that check and think you're going to equalize it later, I mean, you've created a breach there. So having a probate litigator helps you hopefully avoid all of those situations where you could be breaching your duties.
Yeah. And
All right.
and something.
Oh,
Oh, I guess I'm next. Yeah.
you're next. Yes. How can you, as a probate litigator, assist in out of court settlements?
So, for the most part in Texas now, when you are involved in litigation, the court either requires or strongly encourages you to attend mediation. And, you know, 95% of cases these days are settling. So, we pick a mediator. We have a mediator in Fort Worth that we like a lot that does a great job, Tom Henry, and there are a lot of great mediators in Houston too. And so, and both you and I have mediated cases before as mediators. So, we try to we reach out to the mediator and make sure we get a date scheduled, and then it complies with the docket control order, and guide the client through that process. And it's I think it's probably about 50-50. Clients being maybe not excited about the settlement when it's done, but at least having some catharsis, versus the ones who leave mediation and they settled, but they're irritated about it, and that usually sort of goes away once everything gets resolved. But yeah, we definitely make sure that we try to mediate every case, because that is the last chance for the client to have a say so over what happens to the estate. And a lot of times in these cases, it's an all or nothing, right? So, do you really want to put it all on the line, when you're putting it in the hands of 6 or 12 people that may or may not make the right decision, and then potentially go through an appellate process and all these other things? I mean, when you have the opportunity to get it over with, also stop the bleeding. I mean, as much as you and I like to get paid, that's getting paid is nice, but not to our client's detriment. And that's important. That I know that you do the same thing I do, which is when I attend mediation, I remind the client, if we go forward from here today, we still have a few steps left, and this is going to cost you a lot of money. And you may get it back, you may not, but you may get it back in the end. But you're still going to be out that money until that time. So, would you rather resolve it today and stop paying me, or would you rather keep going? So, those are all things they have to consider.
And we've talked a lot about this already, but I'll let you just kind of wrap it up. This whole concept of probate litigator ensuring transparency in the probate process. And again, why is that important, and how do we do that?
I mean, when someone calls and asks a reasonable question, especially a beneficiary of an estate, then you need to answer it. If one of the things that we always do at the end of any independent administration, because it's not required, but I just do it, is we get receipts and releases signed. But along with that receipt and release, I have the executor or administrator to sort of prepare a spreadsheet type accounting, just to debits and credits, just to let everybody know, here's what we started with, here's what we collected, here's what we spent on fees or maintenance of the house or this, that, or the other, and then here's what we're left with, and then here's your share, so that they can't ever come back and say that they weren't given all the information. If someone comes back and then says, well, I want to see the receipts to prove that, then as the beneficiary of the estate, they are entitled to receive that, because our client owes them a fiduciary duty. And so we need to make sure that we are as transparent. I mean, they have a duty of good faith, and they have a duty of loyalty, and also of transparency. And so we need to make sure that our clients comply with those duties.
How do how can we assist or how can we handle conflicts of interest that arise?
So, well, if one way we can handle conflicts of interest is by only representing one party, because the most common situation where that happens is when we represent two co-independent administrators or two executors or two this, whatever. And then at some point during the process, they get into conflict with one another, and then we have to step out because we can't, you know, we can't continue. We've had situations before where conflicts have arisen, and we've been able to sort of nip it in the bud before it went too far. That necessitated us getting out. But really, the issue is more that we need to make sure that, again, it just goes back to the same word: transparency, loyalty, fidelity, and on behalf of our clients to the beneficiaries in the estate. But yeah, I mean, one of the biggest issues is representing more than one party in an estate that sometimes causes a conflict.
What if there's an issue or a dispute over whether the decedent had mental capacity to do the documents they did?
You know, there is there are a couple different ways of dealing with that. One is, if you want to do it as cheaply as possible in the case, I mean, you can have you can have lay witnesses come in and testify about observations that and encounters that they had with the decedent that led them to believe that around the time or whatever that the will was done, that they didn't have capacity. That sometimes that flies, sometimes that doesn't. I mean, your always best bet is to hire an expert witness, obtain medical records, and have them do the analysis of medical records, or even the treating physician to come in and say, well, I was treating Bob for dementia, and his dementia had or had not risen to the level where he was capable of making a will. The threshold for a will contest is actually pretty low in terms of capacity, but still there are times. I mean, we're seeing it more and more of family members going in and days, hours before the decedent passes away, and getting them to sign documents, and you really can tell from looking at a signature, especially in contrast to a signature that was maybe done a few years earlier, how with it that person was when they were signing that document. If it's all over the place or not on the line, or crossing the line, there's questions about. I mean, that's where I start. I look at the signature and say, okay, well, this looks like the same signature this person did, or this looks like a signature of a person who, maybe was under the influence of some sort of medication, or just didn't have the ability to understand what they were doing.
How do we as probate litigators provide peace of mind to families going through this process?
Well, I think just being empathetic about, sometimes we get so wrapped up in the business of the process that we don't think about the fact that these family members are grieving over the loss of a loved one, and that sometimes we don't consider the fact that um, you know a bequest and a will to an individual is more than a bequest and a will, right? It's sometimes it, the beneficiary believes that it's an indication of their value to the person, or some commentary on their relationship, or all sorts of things. And so being empathetic, being mindful of the different layers that there are involved in litigation and the probate process, are really will give the client some level of comfort. I mean, we do this job and it's a hard job, and we talk about death and dying and incapacity and stuff all day long. And so to some extent, especially after 23 and 24 years respectively, you're a little bit jaded and or desensitized to it. But we have to remember these people are coming in, they may not have dealt with this ever before in their life, and this is the first time they're dealing with this. And they see this will that cuts them out or leaves them less than their siblings or leaves their stepmom too much money, and it triggers something in them. And so we just have to keep in mind that that's the case. And that's also the reason why, and I think we talked about it in one of the other earlier podcasts, that sort of doing like the legacy letter is a great idea for the family member along with their will, to give an explanation of why they did what they did in their will. And maybe the explanation won't be great, but at least there'll be an explanation, and that particular beneficiary is not left wondering what it was that they did that caused their dad or mom or sister to not give them something, or the majority, or whatever. So I think that's important. So we have covered the top 25 reasons why having an estate and probate litigator can kind of help guide clients through the process. There are lots of complexities, pitfalls in this process. And so obviously we've explained that, in Texas, you can't be a fiduciary without having an attorney. But more than that, it needs to be someone who's experienced in this area that will help guide you through the process. We'll go back to the same word that we've been using over and over again. It's like the buzzword today: help you maintain the transparency that you need in order to make sure that people are, everybody's informed, and you don't cause unnecessary suspicion in the case. So, any final words, Stace?
No, absolutely. Probate's complicated. And obviously, the larger the estate and the more diverse it is, the more complicated it is. And trying to navigate that on your own can, first of all, lead to unnecessary stress that you absolutely don't need while you're already going through the stress of losing a loved one. And it can also lead to financial loss. You can make decisions that, affect the value of the estate or the value of what you're getting. So having an expert in your corner makes all the difference in the world.
All right. Well, we are thankful for everybody who is watching today. And again, Stacy Kelly, Keith Morris, this is the Before You Go podcast. There are things that you should know. And we try to each time give you some advice that can help you as you go along this process. And we'll see you next time.
Now, before you go, learn more about how Stacy and Keith can help protect you by calling or visiting us on the web. Links to our website and phone number are in the show notes. The information on this podcast is for general information purposes only. Nothing on this podcast should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt, viewing, or listening does not constitute an attorney-client relationship.